Good morning, everybody. My name's Lindsay Abbott, and I'm partner here at Moorcrofts on the employment team, and I'm going to be taking you through this employment law webinar. So we're going to be looking at some key legislative changes for April this year, and then looking forward to October and some provisions that are coming into force, and then beyond into early next year. We are then going to be looking at a case law update, covering some cases on gender critical beliefs and transgender rights, neurodiversity in the workplace, some disciplinary guidance cases, race discrimination and unfair dismissal, and part-time worker cases. Okay, so let's kick off with the legislation update. So on the 6th of April this year, we are going to see provisions scheduled to come into force, including the increase in the collective redundancy award, day one rights to paternity and parental leave, bereaved partners' paternity leave, statutory sick pay reforms, making reports of sexual harassment protected disclosures for whistleblowing, and simplifying the trade union recognition process. The Fair Work Agency will establish on the 7th of April this year, and measures in the Employment Rights Act that are still scheduled to come into force in October this year include the requirement for employers to take all reasonable steps to prevent sexual harassment, preventing third-party harassment, the extension of the Employment Tribunal time limits, and new rights and protections for trade union reps, and strengthening trade union rights in the workplace. Beyond that, looking into 2027, the unfair dismissal qualifying period will reduce to 6 months, and the compensatory award cap will be removed. So let's have a look at these in more detail. Statutory sick pay entitlement will become payable from day one of day one of sickness, and that means that the 3-day waiting period that we've got now will be abolished, and the lower earnings threshold will also be scrapped, which means that all employees will be entitled to receive the lower amount of statutory sick pay of either £123.25 or 80% of the employee's average weekly earnings. So your policies, and if relevant, your contracts will need to be updated to reflect these changes. And we are obviously expecting to see a cost consequence of this. Also expecting to see potentially an increase in short-term absences, because obviously, whereas before people wouldn't get paid for those first 3 days, they might not take the time off. They may be more likely to now. They will be paid for that. On the positive side, it keeps those people that are genuinely off sick from dragging themselves into work and spreading their germs around, potentially. But please review your policies. Also check if you have a contractual sick pay policy that it remains competitive in light of these changes, and make sure that your HR and payroll teams are up to date. So they're across this, because if you get this wrong, we're likely to see complaints and grievances raised. The protective award for redundancy will go up to 180 days on the 6th of April. Collective consultation is something that you may be aware of must take place if you are proposing to dismiss 20 or more employees at one establishment in a 90-day period. So the definition of at one establishment is actually changing next year also, which we will update you on later this year. That's likely to be a threshold that in fact captures more redundancies across an organisation. We touched on it in a previous webinar, in fact. So your obligation is to consult employee representatives, including ways of avoiding the dismissals, reducing the number of dismissals, and mitigating the consequences of those dismissals. Consultations must start in good time and at least 45 days before the dismissal is likely to take effect. If you've got 100 or more likely to be dismissed, and if it's 20 to 100 staff, the minimum period for consultation is 30 days before that first dismissal takes effect. So at the moment, the award is 90 days per pay per employee for getting that wrong, 90 days of actual pay. So there's no cap on that pay. So it's already expensive. It's about to get a lot more expensive if you get it wrong, because that's going up to 180 days pay. and that's for affected employees. So you don't even have to make that person redundant. If they're affected by the redundancy and you've not consulted with them, then that would be caught. So make sure that you are doing proper consultation. There will be a day one right to paternity and unpaid parental leave. So that means that employees will no longer have to wait 26 weeks to be eligible for this right. You will need to update your policies to reflect that change. The notice for paternity leave has been temporarily reduced to 28 days to support this transition period. So if parents have an expected due date of the 5th of April to the 25th of July, they only have to give the 28 days notice, but after the 26th of July, the usual 15-week notice is going to apply. Please note that we have a new right here, bereaved partners paternity leave. Employees will be entitled to take leave from day one of their employment if a child's mother or the primary adopter dies within 52 weeks of the birth or adoption placement. And you are either the child's father or the partner of the child's primary carer, and you're taking leave to care for the child. This is a single period of leave that can start at any time after the bereavement and can last up to 52 weeks after the date of birth or adoption placement. There are regulations in place that set out the notification requirements as well as the entitlement to leave and employment protection. So, for example, right to return to work, keeping in touch days, and protection for dismissal. Please be aware that as this is a new right, you will need a new policy on it. So if you do require a new policy drafting, then please get in touch because we can assist with that. The Employment Rights Act 2025 amends the Employment Rights Act 1996 to provide that it will be a protected disclosure for an employee to report that sexual harassment has occurred, is occurring, or is likely to occur. Sexual harassment complaints are arguably already protected disclosures because it's a breach of an illegal obligation. And employment tribunals do treat them as such. But the fact is you will have to update your whistleblowing policy. This does feel a little bit inauthentic, let's say, but the fact is that now we've got legislative recognition that's going to dispel any debate or ambiguity, and it's going to raise awareness for victims and for potential whistleblowers also. So this is due to come into force on the 6th of April. As I say, little effect in reality because employment tribunals do already treat sexual harassment as a protected disclosure. So claimants do have that protection. Menopause guidance. So around half of the UK population, UK workforce, probably population as well, but I'm not talking about that. Around half of the UK workforce is female, and the Employment Rights Act 2025 is really placing menopause firmly on the agenda. By April 2027, larger employers will be required to evidence a menopause action plan, whilst smaller employers still need to be able to demonstrate fair and consistent support and reasonable adjustments if appropriate. From April this year, a menopause action plan for larger employers will be voluntary but mandatory from 2027. So this is really increasingly becoming a standard of HR governance. The government has realised that historically we have got legislation in place to protect women in the workplace. Historically, the Sex Discrimination Act, the Equal Pay Act, more recently the Equality Act, gender pay gap reporting, but perhaps there are some things that just aren't working because there's clearly still a gender pay gap. So they've come up with equality action plans and this menopause action plan. This will be a documented plan of what an employer plans to do to support and make adjustments to try and minimise those difficulties that menopausal employees might face in the workforce. So that will have to be published. Advice from us, I would say, train managers on reasonable adjustments, manage and on how to manage flexible working requests properly, and review your policies and guidance every year. to make sure that your support is continuous and up to date. The number of tribunal claims that we're seeing now that features menopause is going up. Of course, when women are signed off from work with menopausal symptoms, the doctor's note won't always say menopause. It would say something like stress and anxiety. So clearly it is affecting many women who don't go for promotions and actually leave their jobs because of this as well. So ensure that your possible discrimination claim would be something on age and sex. So ensure that you are supporting and training managers on how to do that too. We have the establishment of a Fair Work Agency on the 7th of April this year. So we've never had a regulator like this before. This is something that's brand new. The Fair Work Agency is going to be responsible for industrial relations and maintaining workplace standards, ensuring that employers and employees comply with the obligations that they are supposed to be complying with. So it's a new UK enforcement body. Full enforcement powers haven't been confirmed yet, so we're expecting that. But we're hoping that the Fair Work Agency is going to regulate things that can be resolved before a matter might get to tribunal. For example, national minimum wage, statutory sick pay, holiday pay, etc. So we would advise clients to keep records of these sorts of things. Otherwise, you could come to the attention of the Fair Work Agency and they can issue fines per worker. So, for example, national minimum wage, there will be a financial penalty to employers in addition to compensation to employees, a minimum £100 fine, maximum £20,000 fine per worker. This will be enforced in the civil courts. The Fair Work Agency can also bring claims on behalf of the worker, even if the worker isn't going to bring that claim himself. October 2026. So the Employment Rights Act 2025 will see the requirement for employers to take all reasonable steps to prevent sexual harassment. So you need to revise your policies and procedures. You'll probably have this in place from 2024, when the obligation came in to take reasonable steps, for employers to take reasonable steps to prevent sexual harassment. So this has been ramped up now, times 100, all reasonable steps to prevent sexual harassment. So we're also going to see the reintroduction of the liability to protect staff from third-party harassment, which you will need to act on now. I'll go into more detail on that. And in October, also the strengthening of trade union rights of access to workplaces, new rights and protections for for trade union reps, and a new statutory duty to tell workers that they can join a trade union. So let's look at third-party harassment. So the Employment Rights Act reintroduces employer liability for third-party harassment in relation to the relevant protected characteristic, where both the third party harasses the employee in the course of their employment and the employer fails to take all reasonable steps to prevent it from happening. So this will be for all characteristics except pregnancy and marriage. So that's age, sex, religion and belief, sexual orientation, gender reassignment, disability, and race. So the reasoning being pregnancy has its own protections. And there is already a duty to take reasonable steps to prevent third-party harassment. That was from October 2024, but it was only directly enforceable by the Equality and Human Rights Commission. So there was nothing an employee could do, well, little an employee could do really to get their rights across, but all that is going to change now. As I said, whistleblowing is expressly extended now to cover disclosures about sexual harassment from April and from October 2026. This duty becomes taking all reasonable steps. Please note that it is going to be difficult to just run the defence of I have trained my managers and I have policies on this. The bar is going to be much higher. You will have liability if you fail to take all reasonable steps to prevent all harassment on protected grounds from a third party. Unfortunately, it's going to be about 8 to 9 months before we get the regulations covering what all reasonable steps might look like. So in between times from now until then, it's going to be a risky time for employers. You've probably got some training and policies and procedures in place from October 2024, but you need to really get ready to roll that out on a much larger scale. It's going to be a huge risk for employers, especially those with client-facing and customer-facing businesses. So you are going to need to do your risk assessments. Again, please do contact us if you require any assistance with that. The issue of how a trade union is recognised in a workplace will be simplified with changes happening on the 6th of April. And there's also some other changes due to come into force in October 2026. We don't deal with a lot of organisations that deal with trade unions. And also I could do another webinar on a whole other webinar on this. But please, if you require any more niche or detailed advice on how trade union recognition is changing, then please contact us. But even if you're sitting there now thinking, well, we don't really have anything to do with trade unions, what's coming into force in October will affect you, will affect everyone. So in October, there's going to be a new duty for employers to inform workers of their right to join a trade union, and that's going to have to be delivered in a written statement. So even if you don't recognise a trade union, you're going to have to do this. We think potentially employers will do this via the contract of employment, or could be, for example, on a visible notice board in the workplace. And we are expecting regulations again on the manner in which this can be given. Also, be aware that from October 26, there's going to be a right of trade union access to the workplace if they cause no unreasonable interference. So that might be taking employees away from their work for a little while to talk about joining a trade union. So they could make reasonable interference, in other words, but we don't really know what that's going to look like yet. That remains to be seen. But as employers, you should be aware that there's a maximum £75,000 fine for failing to let the union in. This is a very strong right. Government is serious about getting unions back into the workplace. And who knows, it may be that with a representative representing the employee, things get resolved, negotiated, sorted out quicker than if that employee is representing themselves, because they will have a trade union rep hopefully being honest with them about the strengths of their case and the merits of their potential claim. And unions do know how to negotiate, and oftentimes employees don't. Employment tribunal time limits. So this is going up from 3 months to 6 months. So currently employees have 3 months less 1 day from the date of dismissal or the breach to make a claim to an employment tribunal or get the ACAS early conciliation process started. That's going up to 6 months. We've already seen an increase in the ACAS early conciliation period to 12 weeks. So now with this 6-month extension, we're potentially going to be looking out for employment tribunal claims for 9 months, which is potentially debilitating. I actually don't know an employment lawyer who thinks this is a good idea, because obviously the employment tribunals are understaffed, under-resourced at the moment, and this is going to increase the backlog. So it is what it is. We'll see how that one pans out. Unfair dismissal in January 2027. Yes, you would have obviously have to have been living under a rock if you hadn't known that the length of service to claim ordinary unfair dismissal is changing and going down to 6 months service. There's also going to be the removal of the cap on a year's salary for compensation, and the maximum compensation, which is currently £118,233, going up on the 6th of April to £123,543, will be scrapped altogether next year. So employees will have 6 months service. They'll be entitled to claim ordinary unfair dismissal. The removal of the 52-week cap on a year's salary, that could be a good thing in some quarters, thinking of lower paid workers who work in some industries in certain areas of the country. Might take them much longer to get a job. But for senior executives' contracts of employment, this could cause issues, which I'm going to touch on. You must be careful that your probationary period isn't going to protect you from this. It doesn't manage the risk. If it's longer than 6 months, it doesn't matter. If that employee has 6 months service, you're still going to have to do a fair dismissal. Even if it's a fixed term contract, it's still a dismissal. So the employee will be entitled to a fair dismissal. You're going to need to think about how you're going to do that after 6 months, and you'll need to update your policies. Please note that for now, redundancy pay entitlement is still 2 years. That's statutory, not contractual. Obviously, you'd have to check your policies for that. So even if you have to dismiss fairly an employee for redundancy after 6 months, they wouldn't be entitled to a statutory redundancy payment. That's what we've got now. That could change, but for now, that's what it is. We think that the real impact here is going to be higher paid individuals. And the ramifications, we think, are probably going to be doing more performance improvement plans with senior executives. Obviously, now you're in a position where you have a senior individual or a higher paid individual and you need to dismiss them. You can pay them off to the tune of £118,000 because that's the maximum compensation they could win in the employment tribunal, even if they earned 200 grand, for example. So this is going to, we think we will end up seeing some other substantial reason dismissals, possibly more termination targets in contracts and performance metrics that affect the condition of trust and confidence. So it may be that you get to a stage where you want to review your contracts of employment for senior executives, being aware, obviously, that employees can't contract out of the right to claim unfair dismissal, but you might want to take some legal advice on looking at clauses in senior contracts. We also have new rules on fire and rehire coming into place in 2027. These rules are going to make variations to hours of work and pay impossible to do unless the business is about to fail or in severe jeopardy. And that doesn't mean you're not doing so well, so you might have to make redundancies. This is really a business that's on its knees. So if you want to harmonise any terms and conditions of employment, you need to do it now. This is going to be a real change from what we've got now. It will be automatically unfair to fire and rehire someone for certain terms, restricted variation, which is hours of work and pay. And this will be a day one right. And then it will be ordinary unfair dismissal for fire and rehire on certain other variations. So because of essentially P&O, you probably all remember that. You're not going to be able to do what they did, fire somebody and rehire somebody else at much lower pay. That's not going to happen. With this, you should also make sure that you've got variation clauses in your contracts of employment. Obviously, you will still have to consult and not breach the implied term of trust and confidence, even if you've got a variation clause. After next year, you will have to potentially take a long time to reach agreement with those staff to get any changes made and follow a fair procedure. Obviously, if you're doing something drastic like cutting someone's pay, then you're unlikely to be able to get away with that simply with a variation clause. Also, if you've got bonus and commission schemes, make sure you've got the right to amend, vary or withdraw. Bonuses and commission are likely to get caught by this because hours of work, as I say, hours of work and pay are the most effective. The government is consulting on exemptions to benefits in kind and expenses, and we will update you on that. Frankly, I could do a whole other webinar on this area of the law, but for now, what you need to be aware of is that if you've got any contractual handbooks or policies, then you need to make them non-contractual as soon as possible and review if there's any parts of those that affect hours, pay and holiday in your non-contractual handbooks too. But variation clauses in your contract, and if you need to harmonise, get on with it and do it now. Okay, so now we're going to have a case law update and look at some recent cases. So first of all, thought we'd look at neurodiversity in the workplace because I've got a couple of cases on this, and it is really a hot topic. There's much greater awareness now of neurodiversity in the workplace, and we have seen a 750% increase in cases referring to ADHD in the tribunal, and that's since 2020, and a 96.3% increase in cases referring to autism between 2020 and 2025. So diagnosis is going up. There's a statistic showing that 1 in 16 people are autistic, but ACAS actually says that 20% of people have either ADHD or autism. It's also a very common cause of occupational health referral. It's the third after mental health and musculoskeletal issues. That's published at the end of last year in Personnel Today. So not everyone will be disabled who has ADHD and autism, because they may not fall within the statutory definition, which is up on the screen now. So you are disabled if you have a physical or mental impairment that has a substantial or long-term negative effect on your ability to do normal day-to-day activities. Substantial is more than minor or trivial. For example, it takes much longer than it usually would to complete a daily task like getting dressed. And long-term means that it has lasted for 12 months or more, or is expected to last for 12 months or more. If someone has an official diagnosis, then they are more likely to fall within the statutory definition. It's also important to remember that 75% of people with autism will also have another mental health condition at the same time, like anxiety, depression, OCD. So neurodivergent individuals can also experience mental health conditions that have a physical effect. So when you're looking at this definition of whether or not somebody is disabled, it's about the effect that it has. You don't need a medically diagnosed impairment to be disabled. So we are looking at neurodiversity in the workplace with the case of Stedman and Haven Leisure Limited. So this gentleman worked in a holiday park. He brought claims against his employer. He had a diagnosis of ADHD and autism, and there was a pre-hearing review to determine whether or not he was disabled. So in this case, the tribunal found that he did have a mental impairment, but there was no substantial adverse effect on his ability to do day-to-day activities. And the judge said that things like, for example, he can go on trains when they're not busy. He's educated, he can do various things. But that was overturned on appeal, and the Employment Appeal Tribunal said that that was wrong. And they said that it's not appropriate to compare the claimant to other individuals when determining whether a substantial adverse effect takes place for the purposes of disability. It's a question of them with the impairment versus them hypothetically without it. So it's not looking at them in the round to determine the disability or if the effects are substantial. So, for example, if somebody can't get a train in rush hour, then that would be a substantial adverse effect. You can't do a balancing act and say, well, he's good in some areas and not in others. If someone has a professional diagnosis to say that they do things substantially differently from normal, then that is obviously evidence. Ultimately, whether or not somebody is disabled is a matter for the employment tribunal to decide, but the effect must be more than minor or trivial. The Employment Appeal Tribunal emphasised 3 important points here. First of all, that you should compare the claimant, how the claimant is with the impairment versus them hypothetically without it. 2, the impairment only needs to have a substantial adverse effect on one daily activity. So in this case, we looked at trains. The tribunal, number 3, the tribunal can't offset strengths in some areas against weaknesses in others. So you don't look at it in a round. Obviously, if somebody has a diagnosis, that's a recognition that the person is significantly different in terms of how they function. So you really would need to take notice of that as an employer. Key takeaways from this: don't downplay an official diagnosis, and don't offset that against any achievements that shows how somebody manages or performs well. That shouldn't override medical evidence. And if somebody is waiting for a diagnosis, you have to make sure that you take anything that they say about how they're functioning. You may have to make reasonable adjustments if they are neurodivergent. That's what they're telling you. So we'll look at another case now, Coram and Capgemini. So this lady had an ADHD diagnosis, which she disclosed to her her employer during her probationary period. And she'd been struggling with certain aspects of her role, and they sent her for an occupational health assessment. The occupational health assessment had recommended training for certain managers on neurodiversity and other reasonable adjustments. The employer didn't implement many of those reasonable adjustments that had been recommended. Now, she'd been struggling to complete objectives already set, and then she was set some additional objectives. And the tribunal found that both deadlines and multitasking placed her at a substantial disadvantage. She continued to undergo performance reviews, and she raised a grievance. She was then eventually dismissed for poor performance, and the tribunal found that deadlines and multitasking had caused her a substantial disadvantage. In fact, what the respondent used to do with other employees was, they had a policy of job carving, but they wouldn't do it for the claimant because she was still on her probationary period. And the tribunal said that that was a failure to make a reasonable adjustment. So this is a case that shows that what disadvantages a neurodivergent individual can affect them, but also how managers deal with it. So where there's a lack of understanding, then there will be even more difficulties. So we would recommend that you look at potentially training staff and managers on how to deal with this sort of thing, and that reasonable adjustments is not just a box ticking exercise. It's about education and awareness, and how to deal with an individual who might need those adjustments. And of course, if your occupational health advises you to make reasonable adjustments, then you should do that. And if you don't, you need to keep a very well documented paper trail of why you're saying that those adjustments aren't reasonable. Also, remember that not all neurodivergent employees are going to be the same. So what adjustments might work for one would not work for another. So you really have to be looking at it on a case-by-case basis. And also make sure that if managers are going to escalate performance concerns or start PIPs, that they are aware of, and they should check whether or not any of the performance issues could be linked to a disability and whether adjustments might help in that context. Okay, so now we're going to look at the case of Milreen and DHL Services. So Mr. Milreen was employed by DHL as an HGV driver from October 2013. And he had been absent from work with vertigo and vestibular migraines for 2 years. In June 2022, he was dismissed on the grounds of medical capability. And Mr. Milreen appealed against this decision. However, there were numerous flaws in the appeal process. So first of all, the allocated manager declined to hear the appeal, and then a replacement manager failed to turn up to the appeal hearing. The HR business partner then asked Mr. Milreen if he could suggest another manager to hear the appeal on some other dates for an appeal hearing. However, that wasn't put in writing, and actually it ended up no appeal hearing was ever held. So Mr. Milreen issued an unfair dismissal claim in the employment tribunal, and they found that they criticised the appeal process, but they actually dismissed his appeal. Dismissed his claim. So he then appealed to the Employment Appeal Tribunal, and they agreed with Mr. Milreen, and they allowed the appeal. And they said that the dismissal was unfair due to the defective appeal. And the judge stated that the statutory test of whether a dismissal is fair requires the whole process to be examined, including the appeal. And the judge went on to state that the failure to offer an appeal or an defective appeal procedure wouldn't automatically amount to an unfair dismissal, but it would be one of the many factors that would be taken into account. Even when the original decision to dismiss is a reasonable one, the overall dismissal can still be found to be unfair. So the fact that arrangements weren't confirmed in writing goes against best practice, left the employee feeling confused in a poorly managed process. So this case is a reminder to employers that you must ensure that a fair procedure has been followed throughout, including the appeal process. So make sure that even when a dismissal is justified, you're handling each stage of the process carefully and fairly in order to avoid a finding that the dismissal is unfair. In another unfair dismissal case, we've got a recent decision by the appeal tribunal again, held that a dismissal of an employee for conduct was fair, even though there were shortcomings in the process, so slightly different to the other case. So this is the case of Allen and Financial Conduct Authority. So Mr. Allen, a colleague of Mr. Allen, raised a complaint with their employer, the Financial Conduct Authority. Following an investigation which included interviews with the colleague, it was found that whilst not all of her accusations were substantiated, there was a reasonable belief that Mr. Allen had sent her a harassing anonymous email. So the anonymous email was an act that constituted harassment. Mr. Allen then raised a complaint about her. Following receipt of the investigation report into his grievance, he emailed his line manager and the line manager of the colleague, referencing findings from this investigation into his complaint. And the FCA then subsequently commenced disciplinary action against him and dismissed him for the anonymous email, which was harassment, and the email to the managers, which was an alleged breach of confidentiality. So he was dismissed for gross misconduct, and he later brought claims in the Employment Tribunal for unfair dismissal, race discrimination and victimisation. Mr. Allen was unsuccessful in his claims, and the Employment Tribunal found that his conduct was the overwhelming reason for the dismissal. He accepted that, had he been the author of the anonymous email, he continued to deny sending it, then that would have justified his dismissal. The tribunal found it reasonable for his employer to conclude that he was the author of that email. So remember, as an employer, you're not looking to prove something beyond reasonable doubt. It's not a criminal court, but what you're looking at is, on the balance of probabilities, do you believe that the employee did that, even though that they're denying it? Mr. Allen then appealed to the EAT and stated that his dismissal was procedurally unfair because the employer had failed to provide him with a copy of the transcripts of the investigation interview with the colleague. The EAT held that failure by the employer to provide the transcripts of the investigation interview with the colleague wasn't unfair. For a dismissal to be fair, there's a requirement that the employer must provide the employee with sufficient information about the alleged misconduct to enable them to answer and to respond to it. In this case, Mr. Allen had been dismissed based on the anonymous email to the colleague and also the email to the line manager and the manager breaching confidentiality because it had referenced part of the investigation, and sufficient evidence had been provided to him in relation to both those emails. This is an important reminder for employers that during investigations and disciplinaries, it is both acceptable and fair to provide employees only with information directly related to the allegations against them, provided that that information is sufficient to allow them to respond meaningfully to those allegations. Okay, so now we're looking at Augustine and Data Cars. So this is about part-time workers. So we know that many of you employ part-time workers, so you will be familiar with these regulations. Mr. Augustine was a part-time minicab driver, and he argued that being charged the flat rate circuit fee of £148 was less favourable treatment on the grounds of his part-time worker status because it proportionally affected him more because he was paid less than somebody getting paid full-time. So there was a lot of debate in the EAT when this got to the EAT. There had been conflicting views from courts about how to treat this issue. And the test that the court said was that the part-time status has to be the effective and predominant cause of the treatment. So the court did acknowledge their disagreements that they had in this case and that's regarding the interpretation of these regulations. And so Mr. Augustine has been granted leave to appeal to the Supreme Court, which will take place this year due to this unresolved legal issue. And the court acknowledged the unsatisfactory state of the law in this area. But this is a case, just to remind you, if you have got part-time workers, just remember that if they are treated inconsistently for whatever reason, that you are ready to explain the differences in the treatment, just in case you get a claim. Right, so we're now going to move on to the case of Kelly and Leonardo UK Limited. So this is a gender reassignment case and gender critical beliefs case. I thought this was an interesting one to go through in light of the Supreme Court ruling last year that ruled that a woman refers to a person's biological sex and not gender identity. That was the case of 4 women, Scotland and Scottish ministers, which we covered in a previous tribunal. This case actually kicked off in 2023, so it was prior to that decision, but I think it's interesting. It's a first instance case, so it's not binding on other courts. It came from the Scottish Employment Tribunal last year in November, but it is interesting. It concerns a challenge to employers' approach to toilets and the balance between sex-based rights, philosophical beliefs, and gender identity. So in this case, Miss Kelly had worked for Leonardo for several years. She had gender critical beliefs, i.e. that sex is immutable and distinct from gender identity, with sex being a material reality that can't be changed. You will be aware of debates with J.K. Rowling being in the press about this and people getting very angry about her gender critical beliefs. So it's these are the beliefs that Miss Kelly held. In 2023, she asked her manager what the employer's policy was on toilets. The manager didn't know and couldn't find out, so Miss Kelly raised this with HR, and she asked what the policy was for access to toilets. Were the female toilets to be used by women only, or were they able to be used by anyone with that gender identity? The company confirmed that access to toilets was based on gender identity and not biological sex, but there wasn't a written policy. Miss Kelly objected to this, and she said that this compromised her and other women's privacy and conflicted with health and safety regulations. So gender critical beliefs are capable of being philosophical beliefs under the Equality Act, so that was protected. That's what Miss Kelly was arguing, and this has been confirmed in various cases, most recently in Higgs and Farmer School, which we dealt with in last year's webinar. So Miss Kelly lodged a grievance. She said it was unlawfully discriminatory that the employer had allowed access to the toilets based on gender identity because there were no single-sex facilities, and this compromised women's safety, privacy, dignity. She alleged harassment and discrimination related to her sex and her gender critical beliefs, and the fact that she'd asked these questions over a year ago and hadn't had a satisfactory answer. The grievance was heard by HR and dismissed, but the employer did agree to introduce some additional single-sex toilet facilities, but she still appealed. Her appeal was not upheld, and the employer had taken legal advice at that point also. They stated that any individual living with that gender identity was entitled to use the facilities of that gender. So in other words, trans women could use the female toilets and trans men could use the male toilets. And they also said that female staff weren't at a material disadvantage given the fact that there were private facilities related to biological sex. And they would discriminate against transgender employees if they changed policy. The tribunal looked at the workplace health and safety regulations, and those regulations require that suitable and sufficient sanitary conveniences are provided. Separate rooms for men and women, unless each convenience is lockable in a room. They also considered the Equality Act, which protects sex and also protects gender reassignment. So the employer had provided enough suitable toilets, including single-sex occupancy toilets, so therefore they met the health and safety regulations. Miss Kelly then stated that the policy was unwanted and related to sex and had the effect of violating her dignity and creating an intimidating and hostile environment, which is the definition for harassment. However, she hadn't reported any difficulties in using the toilets or had any bad encounters. So what her complaint was focusing on was ideology rather than anything else. So she complained about direct sex discrimination and indirect sex discrimination. So she said that trans women using female toilets was less favourable treatment, so direct sex discrimination. So the tribunal then had to consider whether that violated women's privacy more than trans men using male toilets. And they said there was no such disparity. And they also said that the employer had provided these additional single-sex facilities as well. There was no evidence that she was treated less favourably because of her sex. Again, she was arguing on an ideological basis. She then argued on indirect discrimination, saying that the policy put women at a particular disadvantage compared to men because women had greater privacy needs and because of a fear of men in that space. So the tribunal did agree with that to some extent, but there had been no complaints from other women and no report of fear or safety concerns either. So the tribunal found that also Miss Kelly's use of the facilities hadn't changed significantly or materially since the introduction of the policy. She continued to use the same toilets. She hadn't reported any difficulties or problems. So it was all ideological rather than practical. But clearly there are practical difficulties for employers in this kind of area, access to toilet facilities, because you are balancing the needs of biological sex versus gender identity. So the tribunal did conclude that there were issues in that area. The workplace health and safety regulations, that duty had been complied with, but looking at access to toilets is going to be limited to what's reasonably practical. That doesn't necessarily dictate a biological approach or a gender identity approach. So it's really going to depend on whether or not you get complaints or if anybody has a specific difficulty at a specific time. Okay, so we're now looking at the case of London Ambulance Service, NHS Trust and Sodolo. So Mr. Sodolo was a Black African man who was employed by the trust as a health advisor and a trainer. He applied to be a manager for the fourth time. Following an interview, unfortunately, he was unsuccessful. He was told that the four white candidates were stronger than him, and so he requested written feedback on this, which he didn't receive until 2 months later. So he brought an employment tribunal claim against the employer for direct race discrimination in relation to the failed application for promotion and also the delay in providing written feedback. The tribunal held that the decision not to promote Mr. Sodolo was not race discrimination because the trust was able to demonstrate that he had genuinely scored lower than the other white candidates. Regarding the delayed feedback, they found that he had established a prima facie case of discrimination. So in discrimination cases, the burden of proof is on the employee to prove discrimination in the first instance, a prima facie case of discrimination. So if they can prove that, then the burden of proof flips back to the employer, and the employer has to then prove that the reason for the alleged treatment was not discriminatory, it was for something else. So the tribunal had found that the written feedback that he got gave no real detail. The verbal feedback wasn't adequate. And that's what helped him to establish that prima facie case. The chair of the interview panel that hadn't promoted him, who was also Black, had deferred the providing of feedback to him to a white colleague, and there was no explanation given as to why she'd done that. So the trust appealed to the Employment Appeal Tribunal. And the EAT did, however, consider that the tribunal had taken into account irrelevant factors when concluding that there was a prima facie case of race discrimination. So the fact that the delay in giving feedback was poor, the feedback was bare and inadequate, didn't give any meaningful detail, was the employer was criticised for that, but they said that these factors didn't logically suggest that that was because of his race. So that finding of race discrimination was set aside. This case shows how the burden of proof works in discrimination cases, and because the claimant couldn't show the link between the treatment complained of and his race. So the burden of proof didn't shift to the employer. Delays, a poor process, the poor feedback, the lack of detail may be a reason to criticise the employer, but it doesn't necessarily infer race discrimination. But as employers, I would say you're treading a fine line here. So always, if you're in this situation, be careful to manage the process carefully and your communications effectively.